to me, this is the case that I cared about the most out of the entire thing. Obviously, the abortion case is going to be it's going to get a lot more play than this one. But this one actually affects liberty. This one actually affects a more long-term and I think real personal thing. I know abortion's a big deal, but gun rights are essential to liberty. I always kind of make the joke, and it's really not a joke, but it is kind of a joke, that if someone asks me, would you rather have the First Amendment, which they usually mean free speech, would you rather have free speech, or would you rather have the right to keep and bear arms? So would you rather have the First Amendment or the Second Amendment? Which one would you get rid of? And I'd say, go ahead and take away the First Amendment. And they always ask, they'll say, why? And it's like, well, the Second Amendment means I can have a gun. And if I have a gun, I'll just say whatever I want. That's really it. So, this is actually a big deal. And it's much more basic. I think that's why it's such a big deal, is that it's much more basic, the right that it's really enshrining here. So in 2008, you had a case called DC versus Heller, where the Supreme Court finally, after 250 years, finally acknowledged that the Second Amendment gives the individual a right to keep and bear arms. It's an individual right, just like every other right in the Bill of Rights. It's an individual right that allows you to own firearms. That's been true since the founding, and they finally made it so. But because they didn't want to go too far and too broad with the right, it was scaled back a bit and just recognized that the citizen has a basic right to own a weapon. And they did make it clear that it is two separate rights. You have the right to keep arms and bear arms, but they didn't really elaborate on the extent to which you have the right to keep and bear arms. So really, they only acknowledge the keep part, because the states can just go, oh, well then, you can bear arms, you just can't bear arms outside your house, which doesn't make sense. But yeah, it's basically like that. And then in McDonald versus Chicago in 2010, the court followed up on Heller and applied it to all the states. It's not just the federal government that is not allowed to limit your right to keep and bear arms. It's also the states. So you do have a right to keep and bear arms, and the states have to recognize that. So those two cases are really the only Supreme Court cases that surround the Second Amendment. And so since 2010, so over the last 12 years, the Supreme Court has basically been like, no, we're going to treat the Second Amendment as a redhead stepchild. We're just going to shove it off and, we don't worry about it. And I think that has a lot to do with who's on the court, because I think Anthony Kennedy used to be really, wanted to be very even keeled, didn't want to go too far. It wouldn't be surprising if Sandy Hook had a huge impact on him. So Supreme Court justices like Clarence Thomas, like Antonin Scalia, like Samuel Alito couldn't really get to Kennedy and be like, hey, we really need to treat this right as a right. And he probably was not going with it. That's who Anthony Kennedy was, and for good or for bad. So finally, we have a shift in the Supreme Court. Donald Trump gets to appoint 3 new justices, and now we're taking on Second Amendment cases, which is great. So we get to this court case, the New York State Rifle and Pistol Association v. Bruen. This is a case which finally just out in the open recognizes fully that you don't just have the right to keep arms, you also have the right to bear arms. And not just in your house, not anything like that. You have the right to bear arms outside of your house. So the way I'm reading this, and I could be wrong, I'm not a lawyer, but the way I'm reading this is that you have the right to bear arms. The state can still put some restrictions there, but whatever they have to do, whatever the state does, whatever setup they have, whatever scheme they're working on to, as far as permitting and licensing for concealed carry or open carry, whatever it is, it has to be uniform. If you can pass, basically, for example, I think we have some like 27 states in the U.S. that is called constitutional carry. It's basically open carry, like you don't need a permit, but you need to be able to pass a background check. I think that's pretty universal in all the states. If you can pass the background check to buy a gun, you can have a gun, and you can carry it with you. So that is that's not what the court said is what's going on today, but it gives you an idea. It gives you an idea that we are a country that says you can carry a gun. We have the majority of states are allowing people to carry their gun if they are legally allowed to have a gun. Then there are other states who that's called constitutional carry. Basically, it's open carry. You have a shall issue idea, which means there are some states that, look, we're just gonna, you have to, there is a process. You have to, they may have more regulations, like not only pass a background check, but you got to take a certain number of hours of training with it. So for example, for me, there are some states where if I move to that state, I would have to go to the shooting range and show proof that I spent, it could be anywhere from like 8 hours to 40 hours at the shooting range practicing with my weapon so that I became proficient. So that kind of makes sense. Take a gun safety course. Those kind of make sense a little bit. I'm not a big fan of that because then you're telling, I don't know, an elderly person who wants the gun for home defense, and maybe if they're walking down the street, they want to be able to have a gun and stuff like that. You're telling that kind of person, or maybe like, a single mom who is, walking down the street getting groceries like that. You're telling her she can't get a weapon. She has to find time to go to the range so she can carry a gun around. I'm not sure I like that, but at least they make sense. What this case is striking down are things called may issue states or municipalities. Basically, what's called may issue is that the state or whoever they put in charge of issuing permits, you have to give them a reason why you need a gun for self-defense, why you need to carry a gun for self-defense, and it has to be something above and beyond just, I don't feel safe. So in a lot of cities, it definitely doesn't make sense right now because we have a skyrocketing crime rate going on mostly in our cities right now, especially cities like New York, cities like Chicago. There's a skyrocketing crime thing, especially gun crime, and these people want to be able to carry guns and they can't because they're in a may issue jurisdiction, and the state or the local county or city will just be like, no, that's not good enough reason. So, and there are people who have said, look, here's all the death threats I've gotten. There are some famous people like this and some not so famous people. Here are all the death threats I've gotten. I would like to be able to conceal carry. So, can I have a concealed carry permit? And they're just like, no, that's not good enough. So for rich people, for people that are the famous people, they can get private security. They can make that happen. If you're just someone like me who is not famous, but if I start getting death threats, I need a concealed carry permit because if I go out of the house, which I don't very often because I work from home, my wife does most of the shopping. What do I need to leave the house for? But it's, I would have a concealed carry permit. And I currently live in a state that luckily has laws that have been strucken down by this case. So let's go over it just real quick. I don't want to get too much into it. I'll just highlight some things I noticed just in the syllabus. It's a long opinion. As you can see up here, 135 pages. Now, granted, it's a long opinion. Then there are concurring opinions, which are actually really short. And then the dissenting opinion is also really long. So it's, it's it's really long. We'll just put it that way. So I'm not going to read the whole thing. I'm just going to hit some key points in the syllabus, which the syllabus is not the opinion. I definitely recommend you read the opinion. I'm going to go through. I've started reading it earlier today. I haven't gotten through it because, like I said, it's a long read. So I want to say it's like 75 pages long. And it's long. Anyway, so basically, we're just going to go back and just go to what's being held. The New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for defense. So what they're saying is that, in D.C. versus Heller and McDonald versus Chicago, the court held that the Second and 14th Amendments protect an individual right to keep and bear arms for self-defense. Under Heller, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, and to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. So there's a whole bunch of things that go back to the founding and to when the 14th Amendment was ratified back in 1868. So basically what's being said here is that if you're going to violate someone's Second Amendment rights, you have to show that the burden is on you to prove that it is what they're asking for is insane, essentially. Like, there's no way that's legal, essentially. The burden is on the state. The burden is not on the individual. So what has happened is over the last 12 years or so, the district courts and the appellate courts have created this kind of two-step process where they go through and how they determine the cases, and the syllabus kind of goes over it. Since Heller and McDonald, the courts of appeals have developed a two-step framework for analyzing Second Amendment challenges that combines history with means and scrutiny. The court rejects the two-part approach as having one too many steps. Step 1 is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support a second step that applies means and scrutiny in the Second Amendment context. Heller's methodology centered on constitutional text and history. It did not invoke any means tests such as strict or intermediate scrutiny, and expressly rejects any interest balancing inquiry akin to intermediate scrutiny. Basically, there's how the Supreme Court works is they have scrutiny tests. So, for example, if you're going to violate First Amendment, Second Amendment, anything basically in the Bill of Rights, if you're going to violate those, there's some sort of test that they use. And strict scrutiny is the really high bar. Like, you really have to prove that the government has a really good reason to be doing this. For example, if you're going to limit free speech, well, if is someone at a concert, like let's say the performer is halfway through the act and he says, "I want someone to go and beat up the security guard right now." Well, you could say that's free speech, but in the American tradition, inciting violence is not free speech. So, yes, that's something that would be covered under strict scrutiny. They go, "Oh no, that's a good reason. You need to protect the individual from being beaten up by a mob because they will probably not be alive afterwards." So, that is basically what they're doing, is they're rejecting this whole, well, you have to show that it's, you basically have to show that you need to have it. And that's not okay. That's not how rights work. And they go on to kind of express that later. So the Second Amendment is a very product of an interest balancing by the people, and it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms in self-defense. The test of the court set forth in Heller and applies today requires courts to assess whether modern firearm regulations are consistent with the Second Amendment's text and historical understanding. Of course, the regulatory challenges posed by firearms today are not always the same as those that preoccupied the founders in 1791 or the Reconstruction generation in 1868. But the Constitution can and must apply to circumstances beyond those the founders specifically anticipated, even though its meaning is fixed according to the understanding of those who ratified it. Indeed, the court recognized in Heller that at least one way in which the Second Amendment's historically fixed meaning applies to the circumstances, its reference to arms does not apply only to those arms in existence in this 18th century. For example, back in the day, they didn't have social media, they didn't have phones, they didn't have radio, they didn't have TV. But all of those are still covered under the First Amendment, right to free speech, freedom of the press. Those are still covered because it's an in general right to express yourself in any kind of form that could be deemed as speech or written word. So spoken or written word. So that's what we're doing here. We are basically finally recognizing that you have a constitutional right to keep and bear arms. So both rights are finally being recognized in the Constitution. Now, someone might say that, it's different because guns are different. Doesn't matter at all, because we do not treat any other right the way we treat the Second Amendment right now. We don't. This is like, for some reason, a right that it's okay to trample upon. I mean, abortion's not even in the Constitution, and it gets treated way better than your right to guns. So it's it's really good. My main concern with this is actually that it doesn't go far enough. I actually wanted the court to go all the way, and I wanted them to say, no, constitutional carry, you sure, you can have a permit, there's a permitting process, but no, if you can pass a background check, it has to be something where if you are legally allowed to own a gun, you don't have any, recent violent felonies, or even, depends on the violent felony, I guess. It's got to be something like that. We cannot treat the Second Amendment in a bad way. So I wanted them to go all the way. The fact that they didn't kind of bothers me, because now it's a whole bunch of extra cases that have to come before the court, because California, my idiot attorney general, is already talking about, okay, what's a way that we can still take away your right to carry without violating without violating the Constitution. So they're doing what they can already, and that's bothersome to me. And it really bugs me because the Thomas and Alito, the ones that joined this decision, it really this is a really good opinion so far. Like, what I read through here is great, but it really bothers me because we have two people to blame for us not getting constitutional carry throughout the entire country, and it's Brett Kavanaugh and John Roberts. Those two always seem to be the ones that just cave in some way. They join the decision, which is great, and that's good, but yeah, it doesn't. They never want to seem to go all the way members of the liberal side, the left-wing side of the court, the ones that will create rights out of whole cloth and rights that are obviously in the Constitution, just sweep those aside and say, that's not really what it meant, never mind. So it's really those two that did that. And I can show you, it's a really short concurring opinion that Kavanaugh wrote. If I can find it, because it's buried here and so it's so much stuff. But basically, he made sure to write a concurring opinion that made sure to say, now wait a second, now just want to make sure we're clear. This doesn't mean that you can't have a bunch of limitations on the right to keep and bear arms. So just to finish off the actual opinion, here's the final part of it. The constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to the government officers some special need. That's not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. New York's proper cause requirement violates the 14th Amendment, and it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. We therefore reverse the judgment of the Courts of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. So that's great stuff to finish off. The Justice Alito filed a concurring opinion, basically kind of going through like, hey, we just want to, I think he wanted to go farther, and I think that's basically what his opinion was. And then the concurring opinion that bothers me is, like I said, it's always, first of all, it's always the Chief Justice. It's always John Roberts. What the hell is wrong with that guy? He's always such a pussyfooter, and it pisses me off. But I think what's bothering me more is he bringing Kavanaugh along with him. And I don't know if that's what, maybe that's why I had a bad feeling about Kavanaugh, because I didn't really think he was a great pick. I really kind of got behind his nomination once they started accusing him of, gang rape and all that other crap, which is a whole bunch of nonsense. But then you get this case, and he's basically like, I join the court's opinion, and I write separately to underscore two important points about the limits of the court's decision. First, the court's decision does not prohibit states from imposing licensing requirements for carrying a handgun for self-defense. In particular, the court's decision does not affect the existing licensing regimes known as shall issue regimes that are employed in 43 states. So the court's decision addresses only the unusual discretionary licensing regimes known as may issue regimes that are employed in 6 states, including New York. So he made sure that he let all the states know, hey, we're not, if you're shall issue, we're not going that far. Calm down there. You can go ahead and have a shall issue, but it's got to be, you better tailor it, and it better be consistent across the board. So he went out of his way to make sure he kind of undermined the decision a little bit. I know you can argue that it's clarifying, but it is kind of undermining it. And then second, as Heller and McDonald established, and the court today again explains, the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. So properly interpreted, the Second Amendment allows a variety of gun regulations. Heller, as Justice Scalia wrote in the opinion for the court in Heller, and Justice Alito reiterated in relevant part in the principal opinion of McDonald, like most rights, the right secured by the Second Amendment is not unlimited. So again, another thing where he just going out of his way to kind of undermine the opinion. And then Amy Coney Barrett did another, she did an opinion, but it seemed more that she wanted more clarification on kind of a more, she just wanted more clarification for some certain questions that she thought were important. They're meant more for like the people involved in the legalese of it, and that's fine, I guess. She had a concurring opinion that was more, hey, I mean, we didn't really have to answer these questions, but I wish we had, because they're going to create some issues. I think she pointed out, like, it'll probably create issues as far as kind of, legal scholars explaining the Second Amendment jurisprudence and the Second Amendment case law. If they had answered those questions a little bit better. That's how I'm reading it. Like I said, I haven't read this whole decision, and I haven't read all the opinions yet. I read the concurring ones because most of them are only, like 5 pages. I think this one's, 3 pages. So, yeah. So that's my beef. Right now, it's always John Roberts and Kavanaugh. They did the same thing with the vaccine mandates. They decided to side with the liberals and go ahead and force all of our hospital workers to get vaccinated. And guess what? Now we have a shortage of hospital staff. What do you know? So those idiots. But they did this again here. But I'm still really happy. This is finally, after 12 years, a solid opinion from Thomas that lays out that Americans do in fact not only have a right to keep arms, but to bear arms.